We have a terrific group of panelists. Let me first start with our moderator, Nader Salehi. He is a partner at Kirkland and Ellis in the Washington, D.C. office. Nader represents clients in complex internal and government investigations involving the SEC, DOJ, FINRA, and other federal and state regulators. Nader, great to see you. Welcome. Next to Nader, we have Steve Crimmins, a partner at Davis, Wright, Tremaine in Washington, D.C. Steve previously served for 14 years at the SEC, where he was Deputy Chief Litigation Counsel and co-managed the Enforcement Division's trial unit. Welcome, Steve. Next is Jennifer Marietta-Westberg. She is Vice President at Cornerstone Research and the head of its D.C. office. Dr. Marietta-Westberg previously served for 10 years at the SEC, where she was Deputy Chief Economist and Deputy Director of the Division of Economic and Risk Analysis. Welcome, Jennifer. Nice to see you. Finally, we have Jonathan Tuttle. He's a partner at Debevoise, based in the firm's D.C. office. John's practice focuses on representing entities such as public companies, regulated institutions, boards of directors, in enforcement investigations and proceedings. John, welcome back. Nice to see you. Nader, let me turn it over to you.
Thank you. Good morning, everyone. Thank you all for joining us, and looking forward to having a great discussion about insider trading. Sorry that our colleagues at the SEC aren't here. I never thought I'd say this, but we hope to see them back soon. But nonetheless, we have a terrific panel, and we look forward to the discussion. I've always found insider trading to be a really interesting subject, just academically. And one of the things that I find fascinating is if you look back, there's always this long-running debate about whether insider trading should be legal or illegal. And I've found that fascinating. And there are arguments to the effect that it would be a great market efficiency mechanism to allow insider trading to build into the stock prices and provide sort of terrific market forces. But for purposes of this discussion, we're going to assume insider trading will continue to be illegal. We're not going to have that debate. And so we're going to assume what I think is historically true, which is insider trading is A, illegal, and B, relevant regardless of who's in power. And it's one of the areas, if you look back at the statistics, and we'll talk a little bit about this, that regardless of whether you have Democratic or Republican administrations, it continues to be a relevant topic, largely because it implicates basic notions of fairness. But it can get complicated, and we'll talk about how it gets complicated. Before we do, Jennifer, perhaps we could start with just a sense based on the numbers. What do you see, and what do you expect to see going forward in terms of how much insider trading will be relevant to the current administration?
Well, the short answer is I think it will be relevant under Chair Atkins. And just to set the stage on enforcement actions in total, I'll start there, then I'll drill down into insider trading. So while we have seen an increase in enforcement actions in the months since Chair Atkins was sworn in, somewhat of an increase versus the earlier months this year before he was sworn in, we do expect that total actions for fiscal year 2025 will be lower. One point of uncertainty that I want to caveat, though, is I'm not sure with the government shutdown if all of the actions for fiscal year 2025 have actually been posted to the SEC website yet. Cornerstone Research will have a report about SEC enforcement activity coming out a little bit later in November and do a deep dive into that. And in thinking about why actions might be lower, there are at least a couple of hypotheses, and I'm sure more, but we've all seen the discussions from Chair Atkins and others that the SEC in this regime will be focusing on clear-cut fraud and fewer actions related to things like the off-channel communications cases, and what some people argue are sort of lesser charges. And the SEC did acknowledge last year as well that they were trying to really push forward enforcement actions under Gensler. So there's a possibility that some actions were brought forward into fiscal year 2024 that otherwise might have been brought forward in this year. So that could, two reasons that could explain the decline. But during this fiscal year, the SEC has continued to focus on insider trading. Historically, insider trading actions have ranged between approximately 6 to 9% of total actions, and this year appears that it's on a similar track. And I thought it would be interesting for a historical perspective to look at the total insider trading actions that we saw under Trump 1.0, which was the Chair Clayton regime, versus the total actions that we saw for insider trading under Biden and the Chair Gensler's regime. So across the 4 years for Chair Clayton, the 4 fiscal years, there were 153 insider trading actions, and under Chair Gensler's 4 years, there were 136. Now, we're trying here to count mainly unique actions, but sometimes that depends on how the SEC presents the findings. But I think you can think about those roughly as unique actions. So if we average those, that's 38 per year under Chair Clayton and 34 per year under Chair Gensler, so roughly equal. And if you look for fiscal year 2025, there have been a bit over 40 actions so far. So for insider trading, it seems to match what we've seen for the historical actions. And while total actions overall may be lower, I think in this space, it may hold steady.
Thank you. The data seems to support that insider trading continues to be relevant. I'd like to make sure we're not the only panel that doesn't talk about AI. Okay. So let's talk briefly about AI. What is your take on how AI will impact the SEC's insider trading program, and whether the creation of an AI task force is something people should be thinking about when it comes to insider trading?
Well, I'll start with my short answer there, which is I don't expect there to be large impacts relevant to insider trading, at least initially. So as many of you I'm sure know, insider trading detection is already driven well by technology within the SEC and for the exchanges. The SEC has many analytics offices that are focused on harnessing the data that comes into the SEC as well as external data and utilizing that to detect patterns that may be consistent with insider trading. So they already have sophisticated market monitoring tools. Now, where could AI, though, potentially help with efficiencies? One possibility is reviewing the leads that come into the tips, complaints, and referral system, or the TCR system. So this is a massive database, as I'm sure many people know. There's a lot of noise in the database, and so potentially AI tools could be developed that could review the leads that come in, and then harnessing what the SEC has seen historically in terms of leads that may be more predictive, may contain red flags that actually do end up correlating with insider trading activity. So these efforts through AI could potentially lead to matters under investigation or MUIs in a more efficient manner than had been done before. Potentially AI could also do tasks like reviewing account statements, hundreds of account statements, and trying to identify patterns and pulling those out. One consideration with AI, I assume, will be confidentiality with the SEC. So models that they develop, whether those models can utilize information from platforms outside the SEC, I think is yet to be seen. So short-term impact, I think not much, given the SEC's sophisticated use of technology in this space, but there are some rooms for efficiency.
Jennifer, I was just reading this morning, in fact, that FINRA was talking about their use of AI, and one of the things they've talked about was the increased use of AI in their market surveillance program, which, all of us deal with the FINRA notices for our public company clients and others, and that seems to me like a particularly interesting use of AI and something that may catch more than kind of the traditional programming in that.
It may. I saw that as well, and there's certainly a lot of potential there, but more potential in spaces where they don't already have sort of high-tech programs in place. Yeah.
That's terrific. Thank you. We're going to switch gears a little bit, and Stephen, I'd like to turn to you. Insider trading has sometimes been described as a victimless crime. And, I think that sort of debate has underlined some of the recent circuit splits that we've seen when it comes to how you assess and measure and seek disgorgement in insider trading cases. We've largely seen that bubble up to the fore following the Liu decision of the Supreme Court in 2020. Can you help us understand a little bit what is the circuit split? What's the big debate about, and where do we see this discussion going?
Yeah, I think this is kind of a sleeper of an issue that none of us have been paying attention to. There was a decision by the Ninth Circuit.
Fortunately, Steve has been paying attention.
No, only with the last couple of weeks. The decision last week in the Ninth Circuit, and last month in the Ninth Circuit, September 3rd, called SEC versus Sripetch, S-R-I-P-E-T-C-H, kind of really crisply laid out this circuit split that has developed in 5 cases across 4 circuits in just the last 2 years, and that is kind of critical to the core of the SEC's disgorgement remedy. Now, it used to be we were all comfortable with the notion that if a wrongdoer made ill-gotten gains, illegal profits, that would be the disgorgement. That's easy, right? Well, today, the First Circuit and the Fifth Circuit and the Ninth Circuit would agree with you. That's it. That's what the SEC has to show, ill-gotten gains. They have to be disgorged. What's so complicated? The disagreement comes in 2 cases, less than 2 years old, 2 cases from the Second Circuit, which say, no, you've got to show more. Now, the Second Circuit is obviously the big deal. They have the high volume of SEC enforcement cases. And the SEC, the Second Circuit, in its view of the world, says, no, the SEC must, in addition to showing ill-gotten gains on the side of the defendant, must also show investor harm, and specifically investor pecuniary harm. So, okay, SEC enforcement cases, aren't investors generally hurt? That's kind of why they do cases. There's the harm. Where, again, is the problem? The problem comes in certain categories of SEC enforcement cases, and I would say first and foremost is insider trading. Now, none of these cases creating the circuit split over the last 2 years happen to be an insider trading case, but it's about to hit, I think, the world of insider trading enforcement. Why is that? The reason is kind of what Nader was just talking about. A lot of times, you'll have a trader who makes a bundle of money illegally, trading on inside information, breach of fiduciary duty, all that stuff. But when you look at the other side and try to show pecuniary harm, where is it? That's where some people would say victimless crime. They don't really mean victimless. Obviously, it hurts market integrity big time, and that's why we have insider trading enforcement. But who really was out of pocket? Because the bad guy was trading against the market, was trading against prevailing market prices. It's not as though he or she was reaching into somebody else's pocket and taking out money. So if you have to show pecuniary harm to investors, pecuniary loss to investors, you might not be able to show it in insider trading. So that wipes out half the remedy. The insider trading remedy is 1-on-1 disgorgement and a one-time penalty. So much for disgorgement. How did it happen? Very briefly. If you read Sripetch, it'll lay it all out for you if you really have an academic interest in it or are briefing it. But basically it arose from first Liu, which of course created all of our disgorgement issues. Liu, Justice Sotomayor, writing for eight of the justices, said, well, look, disgorgement, she was dealing with what? With 21D5. 21D5 in the Exchange Act was what Congress helpfully added in Sarbanes-Oxley to deal with the fact that disgorgement had been purely an equitable remedy up until 2002. So what does it say? It says that the SEC in 21D5 can get any equitable relief for the benefit of investors. Okay, any equitable relief, that should be disgorgement, right? Of course. So nobody has had a problem with that, except Justice Sotomayor said, well, wait a minute, not so fast. What is an equitable remedy of disgorgement? And then she looked at the language of 21D5, and it says it has to be for the benefit of investors. And picking up on one of the defendant's objections in Liu, she said, well, gee, if you're just going to pay it into the Treasury, how are you really benefiting investors? Maybe it's an open question, her word, open question, whether the SEC can collect if it's just going to pay it into the Treasury. That's what sent us off to the races. The following year, 2021, Congress, again trying to be helpful, glued on to the end of the National Defense Authorization Act, a new provision for the Securities Exchange Act, called 21D7. 21D7, straight and simple, says SEC may get disgorgement as a remedy in any action it brings. That's nice and clear, right? Well, the Fifth Circuit was the first. Here comes the split. The Fifth Circuit was the first to deal with it. And they said, yeah, what could be simpler? Now we have a statutory remedy, 21D7. SEC can get disgorgement. Again, what's the problem? Well, then the Second Circuit got its hands on it in two different cases, two different panels agreeing with each other. And they said, no. Disgorgement, first of all, the equitable limitations of lieu survived the enactment of 21D7. And how could that be? And the Second Circuit answered, well, because look at 21D7. What does it give? What did it give to the SEC? Disgorgement. And disgorgement, historically, as in for centuries, been an equitable remedy, and in lieu, they talked about it as such. So they said, as a result, Congress was trying to be helpful, nice, clear language in 21D7, but they used the word disgorgement, so lieu still reigns strong. And as a result, we're subject to a limitation, equitable limitations, that it has to be for the benefit of investors. You have to have some relief for investors. And it's easy to say, well, okay, so disgorgement is a good thing. It promotes market health, tells people it's a disincentive for insider trading. Yeah, but they said not enough. They said SEC has to show, or the SEC and disgorgement generally has to show pecuniary harm. And it's sort of like vague right now what that means. It means something more than general benefit to investors. It means a showing of pecuniary harm. How do you do that in an insider trading case, which is why we're talking about it at length today? Then that moved on, and the First Circuit dealt with it a year ago, SEC versus Navalier. And they said, we disagree with the second. Looking just at the Sarbox remedy, 21D5, benefit of investors, all right, fine, benefit of investors. Justice Sotomayor didn't really mean pecuniary benefit, just that it's benefiting investors. That's good enough for us here in the First Circuit. And then on last month, the Ninth Circuit got to it in Sripich and said, we agree specifically with the First Circuit, and we specifically disagree with the Second Circuit.
So,
Okay.
Stephen, this is a fascinating issue, and it sounds like we're going to be thinking about it a lot and talking about it a lot in the months and years to come. And that's a really wonderful overview of how the issue developed. Just before we leave it, I'd like to have that discussion go one level down in terms of sort of how specific and concrete the discussion is. When, as a practitioner, Jonathan, Stephen, when you guys are thinking about, when you're defending an insider trading case, is this the kind of issue that you expect to be putting your finger on in white papers, submissions?
You better have it right from day one, in white papers, discussions with the staff, white papers, submissions, and if you take it into litigation, certainly in your briefing. It's core.
And unfortunately, it sounds like we'll still have submissions.
Well, yeah, the big question is the SEC going to say, okay, fine, you don't like disgorgement, we'll get it on the other end. Forget that one-time penalty, we'll get a two-time penalty or a three-time penalty. Will justice pick up the ball and say, okay, well, we'll just do a criminal case and try to get it through forfeiture? I don't think so. If you're in a realm where the message right now is don't go crazy on penalties, be measured in your approach to penalties. And if we've always had one time as kind of the standard, except in egregious insider trading cases, I don't think they're going to make it up there, but we'll have to wait to see. The real question, I think, is what does it actually mean in terms of they have to show pecuniary harm? How granular and detailed does it have to be? And Jonathan, what do you think?
Yeah, I kind of veer a little more towards the cynical side on their ability to kind of ratchet up and say before the standard settlement was a 1-and-1, so one-time disgorgement of the gain or loss avoided and a one-time penalty. if they really lose disgorgement totally without showing investor harm, and people like us push back in the settlement discussion and say, well, you can really only get the one-time penalty now, I don't really think that the SEC is going to be able to stop themselves from saying, yeah, before you were paying twice amount to the Treasury, now you're going to pay a 2 times penalty to the Treasury. So I think that's a likely or a potential outcome.
But it's a fight you as a defense counsel have to have. You have to push it.
I agree. You've got to have that fight, but I'm not so sure that the resistance to penalties is going to cause a 50% reduction in the payment of a standard settlement.
So speaking of numbers, let's turn back to Jennifer for a second. Maybe you could tell us briefly what do the numbers show when we look at disgorgement and financial penalties assessed under the current administration versus prior administrations? Obviously, it's hard to read much into it given the length of time that we've been at play with this administration and the shutdown. But what can you discern from the numbers?
Well, certainly, given Chair Atkins' focus in that his view is he does not want to punish innocent shareholders, actions like the back-channel communications, which over 2022 to 2024 collected $2 billion in penalties, are just not the types of penalties or actions that we expect to see under Chair Atkins. But whether penalties for similar types of cases, like insider trading actions, will be lower under this regime versus others, I think we're going to need more time to see that for the reasons that you've been talking about here. So likely over the next 6 months to a year, we'll have a better view into that.
Thank you. Okay, so we're going to change subjects again. Jonathan, we'll turn to you. For those who practice in the insider trading space, I think folks would generally agree the hardest issue that we often deal with is duty. When is a duty created? When has a duty been breached? Sometimes it's easy because someone signs an NDA or you have an explicit document that creates a duty. Oftentimes that's not the case, and you're left to look to the nature of the relationship with the parties or the circumstances surrounding the discussions to assess whether a duty was created such that you can bring an insider trading case. The Archegos case recently sort of highlighted that issue and talked a lot about what a duty means, how it's created, and how we should be thinking about it. Would you mind giving us an overview of the Archegos case and how it sort of drives that issue?
Sure. Archegos was not an enforcement action. It was a civil case brought by actually several class actions brought by investors in the market at the time that Archegos went under. So Archegos, to remind folks, had executed a number of total return swaps on various companies with, and in this case, the defendants were Morgan Stanley and Goldman, and through those swaps kind of amassed pretty significant economic positions in a number of companies. As happens, those companies' prices started to decline, and the defendants were making increasing margin calls on Archegos under the terms of their TRS, the total return swaps. Ultimately, Archegos said they could no longer pay the margin calls, asked for forbearance, but the defendants said no, and they declared Archegos in default and started to sell the shares that were that were hedging the swaps that they had sold. Obviously, the plaintiffs here were people that were in the market around that time, and so while Goldman and Morgan Stanley, according to the complaint, were able to get out with limited losses, the market and these plaintiffs specifically bore, according to their allegations, most of the drop in those share prices. Those cases were brought under both of the theories around duty. The first allegation that the plaintiffs made was that Archegos itself was an insider. So this was a classical theory of insider trading and they said Archegos was an insider because its economic positions amounted to de facto control or made them a de facto affiliate and insider of the companies. The second was that if that didn't work, then the defendants had misappropriated confidential information from Archegos because they owed a duty to Archegos and had either traded themselves in violation of that duty or had tipped their customers in violation of that duty. Judge Rakoff dismissed the case twice in the Southern District of New York, first on the original complaint and then on an amended complaint. And then the Second Circuit agreed with Judge Rakoff and dismissed with, what I think are really good discussions of the duty element under both theories. So on the classical theory, the Second Circuit held that Archegos' economic positions were not. So they didn't actually own the shares. They were not, in fact, positions that caused them to become an insider, de facto or otherwise, of the companies whose names were part of the swaps. They didn't meet any other characteristics of an insider. They didn't get corporate information. They didn't have any ability to exercise control over the companies. And so the court found, I think, pretty easily and without much gymnastics that there really wasn't a classical theory duty of Archegos to the companies that they were owning. On the misappropriation theory, the court also found that there wasn't a duty from Goldman and Morgan Stanley to Archegos. The court said that they're an arm's length third-party counterparty in kind of commercially negotiated swap transactions. They did not owe any fiduciary-like duties. They did not owe any confidentiality duties in terms of their ability to trade. And in fact, the entire purpose of the agreement was for them to hold and trade the stock. That's what a total return swap is. They're holding it for Archegos, essentially. So on the trading element, the duty took care of the claim exactly. On the tipping element, that the defendants had somehow tipped their kind of favored customers was the allegation, and that drove a lot of the volume. The court went along. They said that, well, the duty enough is going to dismiss this claim, but while we're at it, we'll address the tipping element. And here, Archegos themselves was responsible for most of the volume by their own admission because they were trading in these other names at the time in order to try to keep the prices from falling. So the court really kind of gave them a backhand on both elements of it. But I do recommend the case because it's a great way of just focusing very simply and very clearly on the duty element in both of the theories of insider trading.
Thank you. That's terrific overview. In the interest of time, I'm going to switch subjects again to something that we definitely don't have enough time to exhaust, but we should just at least acknowledge it. And Stephen, maybe have you give us a quick overview, which is cryptos and NFTs.
Oh, yeah.
So, obviously, cryptos are something that this administration is focused on from a number of standpoints. And over the last few years, we've seen questions bubble up about the degree to which trading in crypto or NFTs can constitute insider trading. And that issue will likely to continue to be one that's debated in the years to come as this administration provides, hopefully increasing clarity. But can you give us a quick sense of where the insider trading program seems to be intersecting with crypto and NFTs?
Yeah, I think a lot of the air is out of the balloon. About 2 years ago, we were all really excited about a brave new frontier of insider trading in digital assets. And what was the SEC going to do about it? What was Justice going to do about it? Not a whole lot. It got off with a big bang. First ever case, the Coinbase case, a Coinbase manager who basically had advanced information on when particular tokens were going to be listed. He would tip his brother and their close friend. The friend would actually be the trader, made a bundle. Ultimately, what happened? Insider and brother settled with the SEC, pled in the criminal case. That kind of got put quietly away. The trader actually, I think, is still wanted in the criminal case, but he was defaulted in the SEC civil case about a year ago, and that's kind of been it. SEC, in that case, the pleading was that it involved 25 tokens, and at least 9 of the 25 tokens were securities tokens, a phrase that was in vogue back then. 9 out of 25, and now we hear most tokens are not securities. So what's that going to mean? Interestingly, in defaulting the trader last year, the district court in the Western District of Oregon said, all right, he's in default, but also, as you know, in entering a default judgment, the judge is obliged to look behind and make sure the elements are at least facially satisfied. And the judge looking at it said, well, look, it's these tokens, they seem to satisfy a test in a case called Howie in 1946. And these 9 or whatever seem to be securities. So again, that element is made out. That was before a lot of stuff has happened. Also, with respect to the disgorgement aspect of it, it was before the Ninth Circuit got into it with the case we were talking about earlier. So anyway, not a whole lot has happened. NFTs, of course, was the Chastain case. Somebody had advanced information, or actually was the one who picked what would be featured, the NFT that would be featured on the website of the platform there. And okay, the big news there is U.S. versus Chastain, which we all read about last month, with the Second Circuit had to deal with all that, and it was kind of a mixed outcome in terms of what happened. They vacated the conviction, and they went into an interesting, rather academic discussion. And I guess there's been a lot of that under the wire fraud statute over the last few years, over whether the confidential information must have commercial value to the owner of the information. They had to do a dance around the ancient case from the 1980s of SEC versus Carpenter and U.S. versus Carpenter. It was a wire fraud case. That was the one that would involve the pre-publication information that a journalist used from the Wall Street Journal to trade.
It's pretty amazing when you think about it. It's hard to get your head back into the days when
back then
people got their news from the Wall Street Journal and what was in the A-head moved markets.
It was in the Heard on the Street column. But they said, okay, well, we can see the difference here, because in Carpenter, pre-publication information is the stock and trade of a newspaper, the Wall Street Journal, where, what's going to be featured on this platform's website, which NFT is going to be featured. They use the word tangential. It's of tangential value, that it's not really the stock and trade of the NFT platform. But that was kind of a fine line to cross, and credit to defense counsel for getting through that one. So that's where that sits. Takeaway is, where are we with insider trading in digital assets? We thought it was going to be a really big deal. That's where we are now. And now who knows? Because digital asset enforcement is changing so much. It's just a different view of the world that we have now, a very different view of the world. And other panels will talk about that later today. So much for that one. I think one thing, and I know we're over time, but one thing is, interestingly, in the NFT case, SEC wasn't quite sure they were going to say that was a security yet, so they just had DOJ do a wire fraud case, and that's kind of interesting. Will DOJ do that in other matters, where they basically say, okay, well, technically you don't have the elements of an Exchange Act claim, so we'll just do wire fraud. And wire fraud is very loosely fraud. It's 1343, and the conspiracy is 1349 of Title 18. It's pretty loose. What's going to happen? I think in the next few years, people have tried. I think we'll be trying not to do very adventurous things, but who really knows? And certainly not in the digital asset area. We're just in different times. And but keep your eye on the wire fraud statute in other contexts.
It's fascinating. Thank you, Stephen. Okay, so switching subjects, shadow trading. There's been a lot of debate about shadow trading, what it is, whether it should be illegal. Jonathan, let me turn to you and ask the question that I often find myself confronted with, which is, given the Panawat action and given the finding in that case, we all need to think about shadow trading. And when you're advising registered entities or public companies, what do you tell them about how they should be thinking about shadow trading by their employees? Do they need to address it in their policies and procedures? How does that come up for you?
So I think really, I mean, an important part about Panawat, lots of people focused on the fact in Panawat that the court, and there was a finding that, you know, part of the duty that Panawat owed was because of his company's insider trading policy that incorporated trading in other securities. The court also found that there was a general fiduciary duty because of his employment relationship. And I think when you're advising, or when I'm advising public companies and registered entities, that's something that you have to keep in mind, which is that is information that belongs to your client and their employees. Like all information they get, shouldn't be using it for their own benefit. I mean, if you look at kind of the Archegos case that we just talked about in describing the misappropriation theory, the Second Circuit said the misappropriation theory targets persons who are entrusted with material non-public information and in violation of their fiduciary duty to the source of that information, use the information for their own gain. That's citing the Obis case. So it's really, I get, and we've talked about before, that it creates some compliance challenges if you're trying to monitor kind of shadow trading, but I think having the policy is important to recognize just broadly that employees, whether they're employees of public companies or employees of registered entities, with duties to their investors, whether they're funds on an RIA side or whether they're broker-dealer clients, that they should not be using that information for their own personal gain. I think when it comes to monitoring, you have to realize that's really more of a liability. The policy is a liability kind of shifting policy, right? The employees know that they can't do it. It is difficult to come up with kind of real surveillance and real monitoring. I have a few kind of hedge fund clients who, when they're in transactions in consolidated industries, they will add other companies in that industry to their restricted list to make sure they're blocking trading there. But it is, on the farther afield theories, it's harder to, conceptualize everyone whose price might be affected by information.
Yeah, a lot of times with public companies, we see references to, prohibitions on trading of the subject company and also distributors, customers and the like. Is that too specific? Is that broad enough? What are your thoughts on that?
I think that really drives mostly from the fact that those are the counterparties who public companies often owe duties of confidentiality to. So as in connection with their NDAs or their agreements with their vendors and suppliers and customers, they want to protect and make sure they protect themselves there. I think it's not bad to have the broader. I really believe that it's a good policy for our clients to have just a general prohibition on using our information for their own personal gain.
Yeah, and I, for what it's worth, I totally agree with you. And the issue that has made it complicated when I've had those discussions with clients is the surveillance question. I've had clients say to me, "Fine, you want me to put that in my policies? I can't surveil for it." And if the SEC comes along and says, "How do you ensure that your policies and procedures are being enforced?" I don't really have a good answer for that. And I think that's a challenge for folks.
Yeah, and I think that's going to be a point for the SEC where they're going to have to, actually put some meaning into the word reasonable policies and procedures.
Let's turn to policies and procedures. One of the things that we saw in the prior administration was a number of cases that focused on the reasonableness of policies and procedures, especially when it comes to insider trading and insider trading risk. And obviously, notably, these are cases where there was no allegation of actual insider trading. So insider trading continues to be a focus. Question for the panel: to what degree do you think this administration will bring cases that charge an unreasonable set of policies and procedures with respect to insider trading risk without an underlying insider trading allegation? Thoughts?
I would hope they wouldn't. I mean, not just from our client's perspective, but I think, from from a standard of what are we really teaching the market, and what are we really teaching kind of the regulated group of entities that we're dealing with, whether it's under the broker-dealer rules or under the investment advisory rules. I think to default to a policies and procedures case when you can't prove the underlying insider trading, even in instances where you can, to say that it's, it's an automatic policies and procedures case because you have a rogue employee who circumvents a policy, I think that does real damage to the understanding that these are supposed to be reasonable policies and procedures. They're supposed to be implemented, trained on, and monitored reasonably, not kind of, there isn't an exact guarantee. I think the cases that they brought, some of them are kind of real examples of bad facts make bad law. I think there were, hard feelings, I'm sure, in some of those investigations, and there needed to be an action at the end, and that's what they came up with, were the two settlements. I think the litigated case that they've abandoned against Silver Point was another instance where, it was a case that probably shouldn't have been brought.
Yeah, I totally agree with that sentiment, and I think the Silver Point case is a great example of the shift that I think we're going to see in terms of going from the prior administration to this one. And I would guess if we see a standalone policies and procedures case, it's going to be a case where there's a complete absence of policies and procedures, where there's no debate about its lack of reasonableness. Stephen?
I think also we all heard Chair Atkins answer a SIFMA question, I guess, a few days ago, where he was even expressing some second thoughts about the off-channel communications cases. And I think if you're thinking about more technical cases like that and having second thoughts about it, you're really probably going to be less inclined to do a policies and procedures case. I know it's a different topic, but even still, I mean, and then you think back to ancient times when, let's say, when I can remember Bill McLucas as one of the greatest enforcement directors we've had, making the statement to the staff that we will never bring a litigated negligent fraud case, never a 17A2 and 3 standing alone. We must have scienter. Bill, I think, was saying that in a considered manner, but still, that was kind of the flavor then. Of course, we wanted to do the right thing and do good cases, but the more technical ones, even back then, there were second thoughts about it. Now we see Chair Atkins, expressing concern about enforcement resources. This was really the best stuff to spend our time and effort on. So I think, to your point, Nader, when we deal with policies and procedures, will we see any significant number of standalone policies and procedure cases, things that go after policies and procedures over insider trading surveillance, where we don't have an underlying insider trading problem? I would suggest not, and I think we're all seeing the same thing.
Yeah, well, in the category of be careful what you wish for, those policies and procedures cases, and Jonathan had alluded to this, were sometimes off-ramps for cases that wouldn't otherwise settle. And without sort of getting into any specific case, I could see a situation where you end up, from a defense counsel perspective, wishing you had that off-ramp.
Yeah, I mean, it's the 17A2 and 3 or the books and records internal control provisions on financial accounting cases. It's not difficult to see how they came about. I think from a programmatic standpoint, though, from the division of enforcement, it's just a question of what are we teaching the market with those cases, and how are we kind of driving improvements in regulation, improvements in compliance, and I'm not sure that, I'm not sure there's a whole lot there for some of that.
Well, we weren't sure whether we'd get to 10b5-1 plans. We have just under 2 minutes left. Let's just take a quick second. 10b5-1 plans were a subject of great interest to the prior administration, and there was some rulemaking. There were a couple of cases that were brought that were somewhat novel. Do we expect 10b5-1 plans to continue to be an area of focus for this administration when it comes to insider trading?
I think if another case that looks like it's really abused, I expect the administration would bring that kind of a case. I don't know that they're going to stretch like they will in any matter. I don't think that's really kind of what they're focused on. But I do think, when you look at the Pizer case, which is the CEO who was convicted for insider trading based on 2 10b5-1 plans that he entered into, while he, according to the case, had knowledge that a large customer was going to kind of terminate their agreement. I think, the important thing to keep in mind, at least in advising clients from my perspective, is the extent to which the SEC and the DOJ back up the information from the actual announcement of an event to find that it's material at a time when it's material. And I think companies and counsel really need to be careful kind of making those materiality judgments on events that you anticipate or that might be out there, whether they're transactions or significant agreements. If you look at the Chewy case that the SEC brought last year as well, it really is, they are attaching materiality at pretty early signals of the event. And I think companies just need to be mindful of that in both approving 10b5-1 plans and opening windows and things like that.
It's sort of, we're ending roughly where we started, and I agree with you. It really gets to fundamental notions of right and wrong and fairness. And when you look at some of these cases and the Pizer case, if you're not a securities lawyer and you're not doing insider trading, it's easy to just take a step back, look at it and say, you know what, that shouldn't be okay. You shouldn't be allowed to do that. And I agree sometimes that's going to drive the legal outcome. So with that, thank you everyone. I think we're out of time.